Now, members of the jury, we reach the point in the trial where your responsibilities are brought into play. It has been fortunate for you and the court that in the presentation of this particular litigation you have had counsel's quite capable advice in handling the case. They have given to you that particular ability which is required in order that 12 laymen may have a fair and equitable presentation of facts to pass on the rights and the responsibilities of the parties that are before us. Let us get that clear in our minds. This is not a will contest. It has nothing whatsoever to do with a will or the rights that arise from a will, because the evidence in this case is that the will which this deceased left was properly probated and that executors were created in accordance with the testator's wishes to represent and defend those things which are made part and parcel of his distribution. So get that clear in your mind. We are not passing on any question of wills. We are passing on what the law describes and which is contended by this plaintiff to be a contract, which is different and distinct from any provision made by a will, because a will provides no consideration, and the term of a contract must be explicit and provide a consideration for the doing of that which the other party promises to do. There are, of course, categorical rules by which your minds will be directed in considering testimony, rules which by prestige and by experience have been found wise for you to follow. Therefore, I will state those rules so that you may properly test this particular testimony that has been presented here in relation to the litigation which you have before you as the judges of the facts, and which I have before me as the judge of the law that is to be applied to the particular situation. During the course of a trial, a layman's mind is somewhat disturbed by different things that are created by the atmosphere of the trial. Things happen which, because of your lack of familiarity with what we call the finesse of a trial, sometimes destroy the layman's contemplation in a jury room. So let me call your attention to the applications made by counsel for the respective sides. Counsel for the defendant moved to dismiss this case on certain specific legal grounds which he specified for the purpose of his record and for the protection of his client. The court reserved decision on that motion. Counsel for the plaintiff made a motion for a direction of a verdict, and that motion was denied, and a similar motion was made by counsel for the defendants for the direction of a verdict, and that motion was denied. Disregard all of those particular decisions made by that court, gentlemen, because they have nothing whatsoever to do with this litigation. They involve principles of law that arise between counsel and myself and have nothing whatsoever to do with you, because the law has decreed that you are the sole judges of the facts and the truth and the probability of a story that is presented by the mouths of witnesses, and the court is the sole arbiter of questions of law that arise during the course of the trial. That is very logical, and there is a very sensible protection thrown around that principle, because if I cannot commit an error, these gentlemen take an exception and are protected for the reason that there is a higher court that can cure my error. But if jurymen start to make laws that they believe should be applicable to a situation as distinguished from what the court says, under those circumstances, counsel have no opportunity of noting an exception upon the record. Therefore, an injustice may be created. Counsel have relied upon you that you would try the issues in accordance with the evidence as presented and the law as laid down by the court. So let us understand each other in that respect. You are supreme on questions of fact, and I am supreme on questions of law for the purpose of this trial. And you must take that law from me, gentlemen, whether it is agreeable to you or not, because you have sworn to do so, and that is your duty. That brings to a discussion now of the facts to see whether or not, under the circumstances, there has been presented what is called in law a contract, because under no other guise and no other presumption will it be in your hands to say anything else unless there is established unequivocally by terms direct and clear a contract made with this deceased to pay this young man, the plaintiff, the sum of $50,000 after his demise. The court has permitted a wider scope in the presentation of evidence in order to give you the fullest atmosphere as to what the conditions were during the time of this gentleman's life. He was, to my mind, a fine citizen. So we go now to what the pleadings of this plaintiff are, and it is only with them that we can concern ourselves in connection with the plaintiff's right to your consideration in the sense of a verdict for the sum of $50,000, because it cannot be anything else if it be in favor of the plaintiff. There can be no compromise on your part. You cannot delve into any other kind of a contract and make it more or make it less. We must be controlled alone by what the parties have placed before us as the obligation that you are to pass upon in relation to the facts.